A lease is a valuable interest in real property. Single-family homes, apartments, and mobile homes are leased as residences. Business offices, retail outlets, industrial buildings, and agricultural land are leased for commercial purposes. Thus, a significant number of individuals are involved in the leasing of real property. Landlords, tenants, and brokers should all understand and comply with the laws governing the leasing of property. Landlord-tenant statutes. The relationship between a residential landlord and tenant is governed by the Arizona Residential Landlord and Tenant Act, ARS, Paragraph 33, 1301 ETSEQ. Commercial landlord-tenant relationships are governed by a different set of landlord-tenant statutes. ARS, Paragraph 33, 301 ETU-SEQ. Mobile home parks are governed by yet another set of statutes, the Arizona Mobile Home Parks Residential Landlord and Tenant Act, ARS, Paragraph 33, 1301 ETSEQ. There are significant differences in the laws governing residential, commercial, and mobile home landlord-tenant relationships. Lease agreements. An agreement for leasing for a longer period than 1 year must be in writing to be enforceable. ARS, Paragraph 44, 1016. A verbal rental agreement is generally considered to be a month-to-month tenancy. See ARS, Paragraph 33, 1314. AAR produces a residential rental agreement that is drafted to comply with the Residential Landlord and Tenant Act. A commercial lease is generally drafted by an attorney or by individual brokerage firms. Residential landlords' obligations. In general, residential tenants have a great deal of statutory protection. Pursuant to ARS 33-1322, a landlord must disclose to the tenant in writing at or before the commencement of the rental agreement the name and address of the person authorized to manage the property and an owner or person authorized to act on behalf of the owner for the purpose of service of process and receiving notices and demands. Additionally, the statute requires the landlord to inform the tenant in writing that a free copy of the Arizona Residential Landlord and Tenant Act is available through the Arizona Department of Housing Office. If there is a written rental agreement, the landlord must deliver a signed copy of the rental agreement, with all blank spaces completed, to the tenant within a reasonable time after the agreement is executed. The landlord must maintain a fit premise. ARS, Paragraph 33, 1324 requires a landlord to comply with the requirements of applicable building codes materially affecting health and safety, make all repairs, and do whatever is necessary to put and keep the premises in a fit and habitable condition. Keep all common areas of the premises in a clean and safe condition. Maintain in good and safe working order and condition all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, including elevators, supplied or required to be supplied by him. Provide and maintain appropriate receptacles and conveniences for the removal of ashes, garbage, rubbish, and other waste incidental to the occupancy of the dwelling unit, and arrange for their removal. Supply running water and reasonable amounts of hot water at all times, reasonable heat, and with a few exceptions, supply reasonable air conditioning or cooling. The handling of security deposits is also highly regulated. ARS, Paragraph 33, 1321, prohibits a landlord from demanding a security deposit, however denominated, including, but not limited to, prepaid rent of more than 1 1/2 months' rent. Any fee or deposit not designated as non-refundable is refundable. Further, the purpose of all non-refundable fees or deposits must be stated in writing by the landlord. Upon move-in, a landlord must provide the tenant with a move-in form for specifying any existing damages to the dwelling unit and written notification to the tenant that the tenant may be present at the move-out inspection. When the tenancy is terminated, the prepaid rent and security may be applied to the payment of all rent, and subject to a landlord's duty to mitigate damages, all charges as specified in the lease agreement, including the number of damages that the landlord has suffered by reason of the tenant's failure to maintain the property pursuant to ARS. Paragraph 33, 1341. Within 14 days, excluding Saturdays, Sundays, or other legal holidays, after the termination of the tenancy, the landlord must provide the tenant with an itemized list of all deductions, together with any amounts payable to the tenant. If the landlord fails to comply with these requirements, the tenant may recover twice the amount wrongfully withheld. A landlord may adopt rules or regulations concerning the tenant's use and occupancy of the premises. However, pursuant to ARS, paragraph 33, 1342, the rules or regulations are enforceable only if their purpose is to promote the convenience, safety, or welfare of the tenants in the premises, preserve the landlord's property from abusive use, or make a fair distribution of services and facilities held out for the tenants generally. They are reasonably related to the purpose for which they are adopted. They apply to all tenants in the premises in a fair manner. They are sufficiently explicit in prohibition, direction, or limitation of the tenant's conduct to fairly inform the tenant of what the tenant must or must not do to comply. They are not for the purpose of evading the obligations of the landlord. The tenant has notice of them at the time the tenant enters into the rental agreement. If the landlord adopts a rule or regulation after the tenant enters into the rental agreement, it will be enforceable if a 30-day notice of its adoption is given to the tenant and it does not constitute a substantial modification of the tenant's rental agreement. If the state, county, municipal, or other governmental bodies adopt new ordinances, rules, or other legal provisions affecting existing rental agreements, the landlord may make immediate amendments to lease agreements to bring them into compliance with the law. However, the landlord still must give the tenant written notice of the change. Residential tenants' obligations. A residential tenant also has certain obligations. Pursuant to ARS, paragraph 33, 1341, a tenant must comply with all building codes materially affecting health and safety. Keep the premises as clean and safe as the condition of the premises permits. Dispose of all ashes, rubbish, garbage, and other waste in a clean and safe manner. Keep all plumbing fixtures as clean as their condition permits. Use all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, including elevators, in a reasonable manner. Not destroy, deface, damage, impair, or remove any part of the premises or knowingly permit any person to do so. Not disturb the neighbor's peaceful enjoyment of the premises. A tenant may not unreasonably withhold consent to the landlord to enter the property for inspections, to perform necessary or agreed repairs, decorations, alterations, improvements, and services, or to show the property to prospective or actual buyers, mortgagees, tenants, workmen, or contractors. ARS, paragraph 33, 1343. Except in case of emergency, or if it is impracticable to do so, the landlord must give the tenant at least 2 days' notice of the intent to enter and enter only at reasonable times. A landlord may enter the property without consent in case of an emergency. Remedies. If either the landlord or the tenant fails to comply with their obligations, the Act sets forth specific remedies. Generally, either party must give the other notice and opportunity to cure the noncompliance before taking further action. CARS, paragraph 33, 1361 through paragraph 33, 1377. Rental property registration requirements. ARS, paragraph 33, 1902, requires an owner of residential rental property to provide the county assessor with the following information: the name, address, and telephone number of the property owner. If the property is owned by a corporation, limited liability company, partnership, limited partnership, trust, or real estate investment trust, the name, address, and telephone number of any of the following: for a corporation, a corporate officer; for a partnership, a general partner; for a limited liability company, the managing or administrative member; for a limited partnership, a general partner; for a trust, a trustee; for a real estate investment trust, a general partner or an officer; the street address and parcel number of the property; the year the building was built; If the owner lives out of state, the owner must designate and record with the assessor a statutory agent who lives in this state and who will accept legal service on behalf of the owner. Residential rental property is not to be occupied if the above information is not filed with the county assessor. If a tenant wishes to terminate a tenancy due to the landlord's failure to file this information with the county assessor, the tenant must give the landlord, owner, or managing agent a written 10-day notice to comply. If the owner does not comply within 10 days after receipt of the notice, the tenant may terminate the rental agreement, and the landlord must return all prepaid rent to the tenant and security deposits in accordance with ARS, paragraph 33, 1321d. Further, failure to comply with the statute may subject the owner to civil penalties. Property management agreements. Generally speaking, property managers procure suitable tenants, collect rents, and assist in the maintenance of the property. A property management agreement between the broker and the owner sets forth the property manager's responsibilities and compensation. Property management agreements must be written in clear, unambiguous language and must comply with the requirements set forth in ARS, paragraph 32, 2173.